Well, good afternoon. We're not on the record yet. So far, you're the only one that's zoomed in, Mr. Is it Lorilla?
Close enough, Your Honor. It's actually Lorela, but everyone gets it wrong.
Lorilla. Doesn't rhyme with gorilla.
Does not rhyme with gorilla, no. But it looks like it does. It's like I said, I would say 99 out of 100 people get it wrong.
Well, as soon as we get plaintiff's counsel in, we'll go on the record and get started.
I am plaintiff's counsel, Your Honor. I think we're waiting for Assistant AG Beach.
Oh, I'm sorry. I see that now.
Can you spell gorilla for me or gorilla before we get on the record, please?
Laurila. First
Thank
name Andrew.
Okay.
How are you doing today, Your Honor?
I'm doing well, thank you. How about yourself?
Not bad. I had to change clothes just before I got on here. I have a brand new baby at home, and of course I took her from my wife for a minute, and she just spit up on my suit, coat, and shirt, like Murphy's Law. So fortunately, I'm at home doing this, so I got new clothes, very accessible.
Is this your first child?
Yes.
There's nothing like that experience. I still remember vividly when our first child was born. And back in those days, mom stayed in the hospital for at least a couple days. In my wife's case, she was there for the better part of 5 days. Normal delivery. I think she had a high bilirubin count, so she had to be under that lamp for a little while.
Yep, I'm familiar with that.
They don't keep you hospitalized for that these days. But anyway, so I made several trips into the hospital while my wife was there, getting ready for them to let her come home. And I remember the feeling that I had walking in there that everybody knew this was the new dad coming to see his child. I mean, I was walking on a cloud. We ended up having 4 more, and it's always wonderful to have another child, but it was never like that. It was just a very unique feeling.
Yeah, I know what you mean. Although we had a very interesting, if you want to put it that way, experience. So our daughter was born 29 weeks, so she was like 11 weeks early. My wife got pretty severe, like preeclampsia, that required an emergency C-section. So our daughter spent the first 6.5, almost 7 weeks of her life in the hospital, and we were going back and forth to see her, which was even more challenging because of the pandemic. So I had a lot of walking into the hospital. I know that feeling well.
Wow. She's doing well now?
Yeah, she is. Yeah, fortunately, and I didn't know that much. I didn't know hardly anything about babies, but I learned quite a bit, especially in today's day and age. They can be born that early and be okay. So those 6 weeks in the hospital were just to finish developing. Mainly, it's like a neurological function that allows them to eat. So like sucking and swallowing, that develops around 35 weeks, give or take. So up until that point, she was on like a feeding tube for the first, month and a half, I would say. Only like the last week they took it out, and then she was able to come home. But yeah, they're both doing great. It was, like I said, a very interesting experience. But you mentioned the bilirubin. There's a bunch of babies that in and out of the NICU while we were there that were, some of them were in there for that exact reason, that they needed to be under the lights for a little bit right after they were born.
Yeah, it still is a fairly common issue with newborns.
Yeah. We were in there for a while, and almost all the other babies were there for just a few days. So we got to see a bunch come and go. And I would say maybe like half of them were because of that bilirubin issue. The other half seemed to be like breathing, mild breathing issues at birth.
Well, I don't know where defense counsel is. This is probably a general number for the Attorney General's office. I'm going to try to call that number just to see what's going on.
Yeah, I think I have hit Brian's cell phone number, actually. Why don't you let me try that first?
Okay.
Went straight to voicemail.
I guess he could be tied up in another court. Let me check my email to see if we've received any kind of notice. No, there's nothing there.
Yeah, I tried to I just texted him. I'll give him a minute to see if he responds. I certainly know he's aware of the hearing. For one thing, they filed this, but beyond that, I spoke with him I think it was last week or maybe the end of the week before about this case. Oh, he just texted me and said it's at 3.
No, we'll tell him he's wrong. It's at 1. I don't know why it was at 1. Normally I hear these at 3 o'clock, but obviously his proof of service must have said 1.
Well, if I remember correctly, I think this got moved. Hey, Brian, this is Andrew. I guess so. I don't know. I just go off of what the times that my assistant puts in my calendar. So, yeah, I'm on with the judge right now. Weird. No problem. I got it. All right. He just called me, Your Honor. He said he thought the notice was for 1, and he's very apologetic, and he's going to be on in a minute.
All right. I'll watch my waiting room to see when he makes his appearance, and then we'll go on the record. So have you been working from home or?
Yes. Yep. The whole firm, we've been working from home really since March. There was a period in the middle when things seemed a little bit better where we were doing some stuff in the office, mainly like depositions of our clients. It's just easier to have them come into the office and be able to sit with them when there's a bunch of exhibits. But everything else, and now because of what's going on, we're back to just doing everything completely remotely. How about you guys? Have you been remote for a while?
Well, I mean, for the most part, conduct my hearings virtually, but I'm here at the courthouse.
Right.
But 2 days last week and the full week before, uh, I had to stay home because of someone in the courthouse that tested positive, and we had to self quarantine for whatever the number of days was. And then last week, the 2 days that I stayed home, I had a slight headache in the morning, and the note on the door says, if you're experiencing any of these symptoms, don't enter the building. So
Right.
I mean, it was a pretty typical low grade headache, but I didn't want to violate the rules, so I stayed home. I kind of liked it, frankly, but for challenges with my internet, because we live out in the country. Generally, it worked just fine. A little more work on my part trying to, because I didn't have files with me. I had to access them digitally, and some I printed, some I just kept on the computer screen. So that was a little more cumbersome, but it sure was nice once I was done to be able to take a walk out in my backyard or whatever
Right.
kind of projects.
Yep. I know what you mean there. It's unfortunately, I live 5 minutes from my office. So going into the office is certainly far from burdensome for me. But regardless, it's especially with like having the baby at home now, working from home is helpful just because I can help my wife a little bit more. So she can sleep a little bit more. But it's certainly been just such a strange year. Such a strange year in general with all this stuff. Although I live in Royal Oak, so Metro Detroit, and had this been a normal year, I would have been driving out to see you this morning. So I guess in a sense, this saved me, like a couple hours in the car.
Well, I plan to make Zoom the standard procedure in my courtroom. If anyone wants to attend a hearing remotely, I'm going to allow it. Makes a lot of sense. Why for appearing for a half-hour argument or less and driving 2 hours each way?
Right.
I don't lose anything from this. So I plan to keep this as a regular option if people would prefer not to travel in. Okay, Mr. Beach has appeared. Let me get him in the room. Okay, Shannon, put us on the record.
Okay.
This is a matter of Sedania, I'm not sure how to pronounce it, versus Michigan Department of Corrections.
The name Bridget Cadena.
Cadena?
Cadena, Your Honor.
Okay. All right. Counsel, if you could each state your appearances for the record.
Judge, yes, this is Brian Beach on behalf of the Michigan Department of Corrections.
And Andrew Laurel on behalf of the plaintiff, Bridget Cadena.
Okay, Mr. Beach, this is your motion. I have read your brief, all of your submissions, as well as the response. So you can keep your argument brief.
I will keep that in mind, Your Honor. Yes, not a problem. As I stated in our brief, Your Honor, this case really boils down at this point, because of the statute of limitations, to what's more or less the single allegation and the single complaint that was filed by the plaintiff. And that was the complaint based on the comments that were allegedly made by CO Michael McGlinchey to Bet Beck. But as we explained in our brief, the issue with this is the only complaint that the plaintiff made. She didn't personally witness any of the allegations, and MDOC conducted a full investigation of the complaint, but could not find sufficient evidence to support it. So that basically boils down to, in terms of count 1 and 2, that the only adverse employment action in this case is going to be the constructive discharge. We don't believe plaintiff can show that. And the reason why is, again, she filed a complaint in April. She chose to resign in the middle of June. Though she was unhappy with the results of the investigation, there's no dispute that the complaint was fully investigated. So again, it's more or less based here on what she felt was that she needed to resign based on these comments from the prisoners that she believed had found out about her sexual orientation based on the comments by, or I guess rather on the alleged comments by C.O. McGlinchey. The problem there is that it's all speculation on solely on her part in terms of how any inmates found out. She doesn't have the name of any of the inmates that were present.
So let me stop you there. We at this stage, I'm not I'm not making decisions based on whether somebody's credible or not. We've
Correct.
got a witness who says that the officer in question made specific statements and made them in the presence of several prisoners. And shortly after that, the plaintiff begins hearing from these prisoners comments that would certainly, I think, allow a fact finder to conclude that the only reason they're making these comments to her is because of the statements made by, and I can't keep the name straight, McGlinchey. Yeah.
Correct. Judge, I think the issue here is this is speculation based on comments that were never verified as comments being made. And for that matter, simply because someone's talking about sexual orientation in and itself is not a form of any kind of discriminatory harassment. Someone can talk about sexual orientation and say she's dating a coworker who's female. That in and itself is not harassment, just simply stating a fact. So say he didn't,
right, but
in front of the
there were derogatory comments made about it. It wasn't just that she's dating this person. It was the use of derogatory terms to describe that relationship.
Again, that's incorrect. If you read the statement from Beck, which is, again, the only person that claims to have heard this, Beck by herself is just saying that, well, he also made these other comments as well. Again, the problem, Your Honor, is to move forward in this case, this is someone making an allegation. They can't state who any of these prisoners were. Again, this is an extremely tenuous basis to go forward on, just simply on this allegation that there's no other supporting witnesses for. Again, this is something that anyone could say. I mean, there's no verification for this at all. And what complicates this too is that it wasn't a secret what the plaintiff's sexual orientation was in the facility. So to have the allegation from Beck that no one's able to verify, and that's a single allegation too. There's not any other employees. This isn't widespread. This is one single allegation. To have that combined with the prisoners were.
You broke up there, Mr. Beach. Your image froze, and then we kind of lost what you said. If you could repeat the last point.
No, again, Judge, I'm just saying that just based solely on an allegation that no one was able to verify other than this one person. The plaintiff never heard it, and no one's able to identify any of these prisoners. And the sexual orientation was not a secret in the facility. I mean, the plaintiff was sending pictures to other people that work there. So again, it's to establish a causal connection. Again, in this case, it's extremely, extremely, extremely weak, and it should not be sufficient to go to trial on these allegations without some other kind of evidence to support it. Well, I guess at this point too, I forget where I was, Your Honor, but I think in terms of moving on to, again, I guess just another thing about the constructive discharge. MDOC is not liable for comments from the prisoners. Prisoners make comments. That's part of working in a prison. There's a threat of violence anytime that you step into prison, and that's what prisoners do. And dealing with these hostile comments from prisoners is part of the job. The plaintiff never asked for a reassignment, for any type of help. There was a complaint made, and in 2.5 months, saying that she could no longer work in the facility. That, frankly, just isn't reasonable, based on the fact that she never asked for a different assignment or said that she needed her assignment changed because of this. She didn't take any steps to try to fix if this truly was a problem. It was something that MDOC was unaware of. MDOC can't be indifferent to this issue if they don't know that she's not able to work anymore around it. And again, jeers, comments from the prisoners, that's part of being in a prison. That's what they do. I mean, I think the plaintiff even testified to that at one point, that, that they yell from groups and you can't really verify who's yelling. So again, in terms of the constructive discharge, because that's really the only adverse action in this case, it's simply not enough, Your Honor. Again, it's speculation, and then based on this speculation that it was an intolerable environment and that she could no longer work in, even though she did nothing to try to fix the situation or to ask for a different assignment. The other count in this case, Your Honor, is the hostile work environment claim. And again, we're back to the same issue here, where it's simply not pervasive. It's a single allegation from Beck, who, by the way, is a contractor. There's no other employees involved, and it's a single allegation. MDOC fully investigated it. They weren't able to verify because there were no other witnesses. And the plaintiff, she was never subject to it. She stated that that there were never any comments made directly to her on the basis of her sexual orientation. There was never any comments of any kind of sexual harassment that were directed towards her. So this is, again, a single incident that she didn't hear. And again, there's no other witnesses to it that anybody's been able to come forth with. Again, plaintiff's claim fails here because it's simply not pervasive. And again, one of the other aspects of this too is that simply talking about the fact that plaintiff was dating a coworker is not a form of discriminatory harassment based on sexual orientation. That's just like complaining about any other couple that works together on the same shift. So really what she's left with are 2 alleged slurs during the time period. And again, that MDOC fully investigated it and was not able to verify it. The last claim here, I left one out, Your Honor, was plaintiff's formal request to view her personnel file. MDOC was not obligated to send a copy to plaintiff's counsel based on the fact that plaintiff did not follow the steps that she's required to take in the statute. She needed to ask to see the file in person. There's no requirement under the statute either that MDOC explain to her how to go about getting the personnel file. And in terms of whether this was covered by the affirmative defenses and the answer filed by MDOC, including his failure to state a claim, clearly that's encompassed in this. If a simple reading of the act should have told plaintiff that she failed to file the steps that were necessary, and that's in order to bring a claim first, you have to ask to actually see the file. So we are asking the court to grant our motion in full today, and if the court has any questions, I'd be happy to answer them.
Thank you. Mr. Lorla?
Your Honor, I will be brief. I think the briefing that the parties submitted addresses most of all this, but I do want to clear up a couple things. Defense counsel repeatedly referred to the allegations in this case as one incident or one allegation, which is mischaracterizing the facts. There was multiple comments made by CO McGlinchey regarding plaintiff and her sexual orientation, some of which, as Your Honor mentioned, were offensive slurs, which I don't need to repeat here, but they're addressed in the brief. So it's not like this was one. It's not like this was one comment.
Let me ask you. I saw that this contract employee had, and I can't remember which exhibit it was, but there were two statements that she signed. I'm not she or he, I can't remember, of comments that McGlinchey made. Were there more than just those two statements?
So those were the two statements that she put in her written complaint. But she also told, plaintiff talked with this contractor, Ms. Beck, subsequently, and Beck told her that there was other comments being made, not necessarily by McGlinchey, but this is where the prisoners come into this. So the comments that Beck heard from McGlinchey were the ones that she put in her complaint. And then the subsequent comments were made by inmates. And defense counsel calls this speculation to say that McGlinchey making these derogatory slurs in the presence of inmates that almost immediately thereafter led to inmates making the same derogatory slurs directed at plaintiff is speculative. I mean, certainly at this stage, if you're drawing all the inferences in plaintiff's favor, as we must, it's certainly not speculation. It's more of an inference. It's the analogy, if you walk inside a building and you're wet, you can infer that it's raining. Similarly here, if you've worked somewhere for months without any issues, the inmates don't know about your sexual orientation, and you have a good relationship with these people, and then all of a sudden they hear your coworker calling you a dyke, and then they immediately thereafter start calling you a dyke, drawing that inference in plaintiff's favor, those two things are connected. So it's not speculation to say that they're connected.
So the point that Mr. Beach made is the department can't be responsible for comments that inmates make. I mean, that's why they're there. That's why they're locked up in this place. They don't conform to societal norms. They behave badly. They say, I'm sure, much worse things than what I see in the record here. How does the department, how is it exposed to liability for things that inmates say?
Well, and again, I think the connection is the only reason that these comments were being made, at least based on the record that we have, is that these inmates heard CO McGlinchey making these same comments. If that had never happened, none of this, it certainly hadn't happened before. So it's not like the prisoners are just calling every female CO at the facility a dyke. That's not what was happening. That only occurred after CO McGlinchey made these comments. And the department is responsible for what CO McGlinchey does and whatever is causally connected to his misconduct.
Well, wait a minute. McGlinchey is not a supervisory employee, is he? Isn't he a coworker?
Correct.
So, at least in terms of hostile environment, sexual harassment, the employer is not liable unless it's aware of the behavior and then fails to take steps to stop it. So in this case, as soon as they become aware of McGlinchey's statements, they conduct an investigation. And McGlinchey doesn't say or do anything more after that, does he? I mean, is there any allegation that, even assuming McGlinchey made the statements attributed to him, which I think for purposes of a dispositive motion, I have to assume that he made the statements. But is there any allegation that McGlinchey did anything else after the department was aware of these complaints?
No, Your Honor, no allegation that McGlinchey did anything after the department came aware.
So the only people who allegedly did anything to treat plaintiff's sexual orientation or sexual relationship in a harassing type of comments or behavior are the inmates.
That's not exactly correct, Your Honor. So after the McGlinchey incidents and the investigation, which MDOC says, they did a complete investigation and determined that the complaint didn't have merit. Well, all that actually entails is they sent written questionnaires to the people involved, so Beck, McGlinchey, and Cadena, and asked them for written responses, and they looked at it and they decided, well, the only two people who know about or can possibly talk about what happened here are Beck and McGlinchey. Beck says he made the comments, McGlinchey says he doesn't. Based on that dispute, it's unsubstantiated and it doesn't go anywhere from there. That's their investigatory process. That's all they did here. Nobody was ever interviewed. They didn't really do anything at all. But beyond that, after that investigation had been complete, there was subsequent incidents involving plaintiff's sexual orientation. There was one where she called for support from other COs because there was an issue in the yard, and the officer told her she's gay enough to handle it and doesn't need their help. And then beyond that, she also she being the plaintiff, spoke with Captain Lang about the issues she was having with McGlinchey. She asked to be separated from him. He claims that he reassigned McGlinchey, but both of them testified that never actually happened. He was never reassigned. And then subsequently, another officer told Cadena about comments that Lang was making about her sexual orientation, specifically that her captain asked another female CO if she would sleep with plaintiff if she, being this other CO, was gay too. So it's not like nothing else happened. Sure, McGlinchey didn't say anything after this investigation, but there were certainly other incidents related to her sexual orientation that she perceived, and rightly so, to be negative. When you're having issues with inmates and your supposed relief tells you you're gay enough to handle this on your own, we don't need to come help you. I mean, that's not only offensive, but dangerous. So there was additional stuff that happened here. It just didn't come from McGlinchey.
So I want to make sure I understand. McGlinchey is referred to as plaintiff's relief. Does that mean he does the same job and takes over for her at the end of her shift?
No. So she was working in the chow hall, and when she needed a break, McGlinchey was the one who would come spell her, I believe is how that happened. Whenever she needed a break, he's the one who would come relieve her.
And she doesn't allege that other than perhaps wishing that he wasn't the one providing her with relief, that he said or did anything to her.
That is correct.
She testified that in all their interactions, he behaved professionally or something to that effect.
Yes, in general, that's correct. I don't recall her exact testimony on that issue, but certainly in general, there is no allegation that McGlinchey ever said or did anything directly to her.
You can continue.
Your Honor, I don't really have anything else to discuss. Like I said, I think all of this is laid out and fleshed out very well in the briefing. So I just feel like I'll be repeating what's in the brief based on, like I said, I just wanted to clarify, that one kind of factual issue. But beyond that, I don't have anything else.
And anything further, Mr. Beach?
I was just going to clarify. I think counsel explained it, but just for clarification for the court, yeah, there was the complaint by Beck, but the complaint, yes, there's a complaint she made, and then there's a written statement that is in the packet, if that makes sense. She actually did the written complaint, and the plaintiff joined in it, and then they both did written statements. So there's not two separate incidents. It's all one. It's all part of the same thing, if that makes sense. And then the only other thing I would point out would be the allegations concerning Captain Lang and that someone possibly said that she was gay enough to handle anything. There were no complaints that were filed about any of those incidents. And with the gay enough, I don't know if plaintiff was even able to say who even said that. So all the complaints in this case were fully investigated by the Department of Corrections. Just one other comment too. Again, the causal that there's a connection between the statements that were made, like by McGlinchey, assuming that they occurred, to Beck, to say that caused the inmates to speak, that also assumes that, around the same time that he made the comments, part of that seems to be, if the comments are true, that it was shortly before this is when the plaintiff's girlfriend came to work at the same facility. So they're both working together on the same shift, as well as plaintiff also sent the photo to the other coworkers. So there was a lot of stuff that happened at this same time to pick out one, to say it was these comments that caused prisoners to find out, again, is purely based on speculation and ignores that any of these other things could have been the cause as well. So that's all I have. Thank you, Your Honor.
Nothing else for me, Your Honor. Thank you for your time today.
All right. So as I step back to analyze these claims, I mean, there's no question that the statements attributed to McGlinchey, I have to assume for purposes of this motion, were in fact made. They clearly are derogatory towards plaintiff and her sexual preference. I think that's something that for purposes of this motion has to be assumed. I can't, as the department did in its investigation, said, well, we only have one person saying you said this, you say you didn't. There's nothing more we can do about this. But those statements in and of themselves aren't sufficient to create liability for the defendant. As soon as the defendant investigated them, and even though it didn't make a finding that the statements were in fact made, there isn't anything to suggest that the specific complaint that was made, McGlinchey making derogatory statements, continued. That isn't any part of plaintiff's claim that anything McGlinchey said after this point contributed to a hostile work environment, anything after those statements. Instead, what we have are an inference that the only reason prisoners who are not otherwise going to subject the department to liability for catcalls and the kind of things that prisoners say, the only connection there is, well, McGlinchey said this in front of prisoners And now the prisoners are saying the same thing or saying similar things. But we also have to couple that with the fact that right around the same time, the person with whom the plaintiff has a relationship actually comes to work at the same facility. And the plaintiff is making known to some coworkers, at least, that the two of them are a couple. That is certainly equally plausible that prisoners know that. Prisoners have found this out. Those are the kind of things that are talked about. And that in and of itself isn't something, and merely being aware that there's a same-sex relationship taking place among two employees at the facility, that in and of itself isn't harassment. It isn't discriminatory. It's just simply observation of the reality of that relationship. So to make the jump from McGlinchey said this in front of prisoners, and now prisoners are treating her differently because of something McGlinchey said, when at the same time, it's also known by her own statements that the paramour is now working in the same facility. How do we draw the causal connection that it was only because of what McGlinchey said that this is taking place? I mean, it is so tenuous. And frankly, all of plaintiff's claims flow from this same factual assumption. It is extremely tenuous. If we were today looking at evidence presented to a jury, and that's the only evidence that was presented, the court would be hard pressed to allow a jury even to return a verdict based on such tenuous evidence. But at the dispositive motion stage, the court certainly must resolve inferences in favor of the non-moving party. And even though I believe this connection is extremely tenuous, I think for purposes of ruling on a dispositive motion, I cannot conclusively say that there is no genuine issue of material fact. So I'm going to deny the motion. I would, given how tenuous this is, I would strongly encourage the parties to talk about a resolution. I think this is a very weak case, but not so weak that I feel comfortable disposing of it at a summary motion. So Mr. Lorela, you will prepare an order denying the defendant's motion.
Thank you, Your Honor.
What about, Judge, just one more thing. What about the Buller-Polwicki claim?
I'm sorry, I didn't address that. I'm very familiar with that act. It clearly entitles an employee to a copy of their record only after they have taken the time to review the record first. There's no genuine issue of fact. She did not do that. She simply, through her attorney, sent in a request for the record. And even though the reason given for its denial based on FOIA, I don't believe is a valid reason, ultimately the plaintiff has to show she was entitled to a copy of her record. And she can only do that if she looks at it first. She didn't do that, so I'm going to deny that. I'm going to dismiss that claim.
Okay. All right. Thank you, Your Honor.
Thank you, Your Honor.
Thank you,
Your Honor,
counsel.
Can we talk briefly before, or we can go off the record, but I think it's worth, since we're all here. We
Sure,
submitted.
hold on a second. Hold on a second. Shannon, take us off the record and let me